Thank you. I think I'd better start with a disclaimer. We've been asked to give a very objective, factual presentation today, which is my aim. But over the years I have undertaken quite a lot of work and been paid for it by the European Commission. But on the other hand, I have also represented various clients in suing the European Commission in the UK's courts and also in the European Court of Justice, in which we have alleged that they and the other institutions of the EU have abused their powers. I think I can also tell you that I haven't made up my mind. I'm hoping that today's presentations will help in that. So I have sincerely tried to put together a presentation that is, as far as possible, objective. So, sovereignty. Well, this is a concept that is used a lot in the current debate, and I think the most emblematic expressions of sovereignty are the power to make laws and the power to enforce laws. The Leave campaign will argue that we've been robbed of our sovereignty, that the only way to get it back is to leave the EU. The Remain campaign argue that by pooling or sharing our sovereignty, that we can achieve much more working with the other countries in Europe. And then insofar as we've had to give up our sovereignty for that, it's a price worth paying. So I'm not going to get into that debate. What I'd like to do is to examine the nature and the functioning of EU law. And Mr. Mason's given a fantastic presentation of the structure of the EU and the institutions and what they do, so I won't have to go over that. And of course you've had the history as well. So I'm going to focus on the nature of EU law and the way in which it functions in the EU and in relation to the member states. So essentially I'm going to do this by answering three questions, or at least attempting to do so. What is EU law? How much power does the EU have to make laws and to enforce them? And in practice, to what extent are we governed by EU law as a nation and as citizens? So in its broadest sense, EU law encompasses the EU Constitution and all of the rules and the regulations that are made by the institutions exercising the power that has been conferred upon them by that Constitution. So we begin with the Constitution. And this is made up of the treaties entered into by the member states, beginning with the Treaty of Rome in 1957 and ending with the Treaty of Lisbon in 2007, and numerous and extensive protocols. And these treaties have been helpfully published in consolidated versions, which gives us two constitutional documents: the Treaty of the European Union, and this sets out the objectives of the EU and also describes the institutional framework, and then the Treaty on the Functioning of the European Union, which, as the name indicates, sets out how the institutions operate and, crucially for the purposes of this talk, what powers are conferred on the institutions to make laws directed at member states and their citizens. It's also necessary to mention the Charter of Fundamental Rights. This was adopted by the member states in the Lisbon Treaty in 2007. It is in effect the EU's version of the Convention of Human Rights, but it does contain more extensive rights. So, for example, the right to strike and the right to protection to personal data. The Charter's had a somewhat controversial history. When it was introduced, we were told by the UK government that it was a political measure and wouldn't really have any legal effect. But since then, the European Court of Justice and indeed our own courts, following the lead of the European Court of Justice, has confirmed that the Charter does apply in circumstances where the institutions of the EU are making laws or when they're being given effect to in member states. And there are two fundamental concepts of the EU Constitution, which in different ways have been covered by the presentations this morning. The first is known as the principle of conferral. None of these terms actually convey what was meant, but you can sort of work it out after a while. And what this means is that the EU institutions, and here we're talking primarily about the Council and the Parliament, can only make laws in those specific areas identified in the treaties. And this is really important. The technical term is those areas in which they're given competence. And some examples would be the environment, for example, agriculture and fisheries and transport. And I'll come back to this range of areas where the EU has competence later. So that's the first principle. The second principle is that of the primacy of EU law. And very simply, this means that the EU institutions, when they make laws in the areas of their competence, produce laws that take precedence over any laws made either by our Parliament or made by our judges. So having looked at the basic constitutional framework, I now just want to say a little bit about the types of EU laws or instruments that are produced. And broadly there are two. There are the directives, which, as the name perhaps suggests, direct the member states to pass their own laws to give effect to the directives. So the directives generally set out the legal principles and policies that then need to be fleshed out by the parliaments of the member states. And then regulations, which now tend to be the usual way in which the EU passes law, and these have direct effect. So they apply directly the moment they're passed. There's no need for any implementation. So having considered what EU law is, we can now turn to the question which goes to the heart of the issue of sovereignty, and that is, how much power does the EU have to make laws and enforce them? So how much power does it actually have to make laws and enforce them? And taking first the power to make laws, as I've explained, the EU institutions only have competence to make laws in specific areas, and these are to be found primarily in two articles of the Treaty on the Functioning of the European Union, Articles 3 and 4. So this is Article 3, and what this does is to set out those areas of competence where the EU has exclusive competence, so the member states can't in any way interfere in these areas. And they're the obvious ones, if you think about it. The custom union, so a system of custom duties applying to goods and services coming from outside the EU. Competition rules to do with the single market. Euro monetary policy, the conservation of marine biological resources. Common commercial policy, what that refers to is the liberalisation of world trade. So, for example, the EU's participation in the WTO. And then we have the areas of shared competence in which the member states can make laws, but only insofar as the EU chooses not to do so. And this is a longer list. The internal market, social policy, but for limited purposes only, and these are spelt out elsewhere in the treaties. So, for example, the power to make laws with regards to people with disabilities. Then economic, social and territorial cohesion, that refers to providing financial and other assistance to deprived regions within the EU. Agriculture and fisheries, environment, consumer protection, transport, trans-European networks, they're networks to do with transport, energy, area of freedom, security and justice. This is a power to provide protection from international crime and terrorism, and also to ensure access to justice within member states. And then finally, common safety concerns and public health matters. But again, this is limited generally to provide support for governments wanting to organise health protection. So, looking at this list, it's clearly comprehensive, and it's also clear that it's subject to quite a lot of interpretation, and there lies something of a problem. And we'll come back to that in a moment. I suppose it might be worth just mentioning the areas that aren't covered, and the ones that occur to me are government welfare and social security, international trade outside the EU, the justice system, the family, education, public health and defence. But of course in all these areas, indirectly, the EU can also legislate. Now, I've mentioned that these areas of competence are not very well spelled out. And what we've seen over the years is that the EU institutions have taken a very liberal view of their powers, and have, as a result, made laws that, on the face of it, seem well and truly beyond the powers that they've been given. This lawmaking activism, it has been dubbed treaty competence creep. Not a very nice name. And this is particularly evident in laws made on the basis of one of the most, or the most key competence really, the internal market competence. So the internal market competence allows the EU to make laws for the sake of the smooth functioning of the internal market by removing any obstacles to trade, and with a view to trying to create a level playing field, which for those whose eyesight might not be very good, this is not. Using this competence, EU has introduced regulation from everything from the rights of employees to the rules governing the admission of lawyers to their profession, to the regulation of tobacco and health. And that's despite the fact that the EU has no competence in the areas of employment, the professions, or public health. When laws have been introduced in this way, under the internal market competence, they have often been subject to challenges in the courts on the basis that the EU has acted ultra vires or beyond its powers. However, the ECJ has consistently supported the expansionist approach of the EU, so much so that there's only one occasion when the European Court of Justice actually declared that an EU law was void for want of competence. And that was a case on the validity of a directive banning the advertising of tobacco products, which if I had time I would go into, but as I don't, I won't. Now, the member states have been concerned about this expansionist approach of the EU, and at the insistence of the UK and a number of other member states, have had enshrined in the treaties two principles with a view to ensuring that the EU institutions take seriously the need to remain within their competence. And there are some mechanisms that have been put in place to help them in that. And these are the principles of subsidiarity. So the Union, in areas of shared competence, of course, shall only act if and insofar as the objectives of the proposed action cannot be sufficiently achieved by member states. So there has to be consideration given to whether the member states could do what the EU is considering doing. And then the principle of proportionality, which is that the content and form of the Union action shall not exceed what is necessary to achieve the objectives of the treaty. So a requirement that the EU does no more than it needs to do in order to achieve its purpose. Now, how much of a difference the establishment of these principles has made is something that's hotly debated. But in practical terms, what this means is that every time the Commission proposes a law, it has to consider seriously the extent to which these principles are complied with and set out in detail why it thinks that they are compliant. And then there is now a period afforded to the parliaments of the member states to review any legislation, particularly with regards to subsidiarity, and to give an opinion to the Commission as to whether they think that the proposed legislation complies with that principle or not. So that's the power of the EU to make laws. In terms of enforcement, I think I may have some good news for at least some of you here, and that is that for the most part, when it comes to enforcement, that really is a matter of responsibility for the member states. So, for example, if in this country there was a question as to whether or not a trader had sold goods in contravention of the directive on unfair commercial practices, it would be for the CPS or some other enforcement authority to decide whether to bring a prosecution. Similarly, if a manufacturer had produced a medicine that was thought might be in contravention of the EU Medicines Directive, it would be for the CPS or the relevant agency in this country to mount a prosecution. And the determination of that prosecution would be in accordance with the procedures and practices of our courts. So when it comes to enforcement, that's very much a matter for the member states and their institutions. So we come now to the third question. We've looked at the power to make laws, the power to enforce laws. And the third question is, well, in practice, to what extent are we actually regulated by EU law? It's a question that a lot of people keep asking. So what I thought I would do is take the situation that we find ourselves in right now and look at the EU laws that are in play. So perhaps we could start with the clothes that we're wearing. These are regulated by the EU textile regulation. For those male or female who are wearing makeup, this is regulated by the cosmetics regulation, which governs everything from product safety to the advertising claims that could be made when cosmetics are sold. If any of you are taking medicine, then this is regulated by the Medicines Directive and numerous other regulations. And in fact, we have a very comprehensive system of licensing and regulation of medicines, which is overseen by the European Medicines Agency.
2 minutes.
And for those of you who are blessed with an artificial hip, and I know one or two, these are regulated by the Medical Devices Directive. For those of you who've been unable to give up smoking, your cigarettes are regulated by various EU laws, including the Tobacco Products Directive. And those who have switched to vaping using electronic cigarettes, they are regulated by the same directive. Your mobile phones and any other electronic gadgets you may have brought, these are regulated by various EU laws, including the Radio and Telecommunications Terminal Equipment Directive, covering everything from product safety to roaming charges. The chairs you're sitting on, this lectern, and the various pieces of equipment in the room are all subject to the General Product Safety Directive and the Product Liability Directive. And there are numerous EU safety standards pursuant to the first of those. And if any chemicals, as no doubt they have been, were used in the manufacture of these items, then their use would have been governed by the Regulation on Registration, Evaluation, Authorization and Restriction of Chemicals, known as the REACH Directive. When we break for lunch, if we could go down the lift, then that would be regulated by the Lifts Directive. The food that we're going to eat will be regulated by the General Food Law Regulation and numerous EU laws, including a controversial law, the Regulation on Genetically Modified Food. And these cover all aspects of food safety, from primary production, food processing, storage to transport and retail sale, and they're overseen by the European Food Safety Agency. The quality of the air that we breathe is regulated by the Air Quality Framework Directive. The light in this room is emitted from bulbs which are subject to the energy-saving requirements of the Eco-Design Directive, and the outside noise that we're subject to is regulated by the Environmental Noise Directive. And I assure you this list is not exhaustive, but I hope it gives you an indication of the pervasiveness of EU law and the extent to which we benefit from it, or suffer it, depending on your point of view. And you'll be pleased to know that the presentations that are being given today, and anything that you might say, as far as I can tell, but you never know, is not covered by any EU law. Is that it? Okay.
That's it. Thank you.